Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about bankruptcy with an interplay on divorce and family law. Joining me as always, co-host Jesse Barrientes. Jesse, how are you?
I'm doing fantastic, Dave. How about yourself?
I'm doing pretty good.
Having a good, well, I don't know if we could say summer or spring yet, but...
We're getting there.
Yeah,
we're getting there, but it's not so good for everybody. So a lot of people need help. They need a fresh start. They're getting bothered by bill collectors. They may be losing their house. They might have a car that they're behind on. The wolf is always at the door. So Chapter 7 or Chapter 13 bankruptcy are two options to help people either get out of debt or reorganize the debt and keep the creditors at bay. What's your thought on the interplay with bankruptcy and divorce and how you see that as a factor?
Well, if you're looking at divorce, okay, basically a divorce is dividing up the pie equitably. So you divide what the assets are, what the liability is. You have to consider who's in a better position to pay this or that, who has the retirement to kind of just to make it, to equalize everything to get that going. But also, though, for bankruptcy, regardless of whether it is Chapter 7 or Chapter 13, once somebody files that bankruptcy, then what happens, Dave? There's a bankruptcy estate, right?
Right. A bankruptcy estate is created. There's an automatic stay, which is basically a big stop sign that goes out telling creditors they cannot take certain action. So if they were calling, they have to stop. If they were suing, they have to pause that action. If they were garnishing, that gets stopped too. Everything kind of has to get sorted out.
What about the interest?
Well, interest could accrue depending on what chapter, but typically in a Chapter 7, the debts are eliminated, so there is no interest, and the creditors have to cease their collection efforts. And usually their clients, the creditors' clients, walk away with nothing in a standard Chapter 7 fresh start.
Well, before we talk about some more interplay, I think it's important for our audience to kind of get certainly a basic idea of the different chapters. You talked about Chapter 7 and Chapter 13, and I know they're probably familiar with divorce. We could just touch on that a little bit after we discuss those things and talk a little more on the interplay. So in a Chapter 7, what is a Chapter 7?
Well, Chapter 7 is basically a fresh start. That's where someone who has very little in the way of assets and a lot of debt, typically unsecured debt, but sometimes secured by property, wants to avail themselves of the federal law that allows them to get a fresh start of most of their debt. Not necessarily all. There are certain debts that don't go away in a Chapter 7, such as student loans, recent taxes.
Recent taxes.
Recent parking tickets.
Go back. Let's go back. So recent taxes. So is there a number of years? Or?
Yeah. Taxes within the last 3 years are not eliminated.
Okay.
If taxes are more than 3 years old and other requirements are satisfied, like filing of returns and things like that, then it's possible that old tax debt could be eliminated. Okay. Income taxes I'm talking about.
So it's not a sure thing?
Certainly not. Okay. It's something that you definitely don't want to rely upon.
Well, what about the parking tickets? I know, I remember I used to have people, it's been a little while, but I had somebody come in, and they weren't really parking tickets. Somebody had, can you imagine accruing $30,000 plus in tolls? But it's not just tolls. It's the penalty, it's the interest, it's the continued adding and compounding of all this stuff. So
tolls are a separate item that has to be basically repaid to a certain extent in a Chapter 13. But what's interesting, in the last 6 months or so, the city of Chicago, only the city of Chicago, in regard to parking tickets, they passed an ordinance that said this: if you file a Chapter 7 and complete your case, they will wipe out any parking ticket more than 3 years old, provided you work out a payment plan for whatever you incurred within the last 3 years.
What if you didn't incur anything in the last 3 years? Then you're good. You don't have to pay anything.
You've eliminated all of your parking ticket debt as long as you complete the Chapter 7. And also keep this in mind. The part that you have to repay in a Chapter 7, what you've incurred in the last 3 years, that's just the actual ticket. So they're taking out the doubling, they're taking out...
Oh, so there's no penalties, there's no interest. So if I got a ticket that cost me, $100 or $250 because I parked in a handicap spot, that's what I would have to pay.
Right,
if
just
it's
the actual ticket amount.
Okay.
Yeah, what the city figured was we weren't getting any payments or collecting very much in these Chapter 13 cases, so let's give them an opportunity to eliminate some debt in a Chapter 7 as long as they're willing to work out a payment plan. And by the way, those payment plans, they can be a 3-year plan, very affordable. So
Oh, so they're working. So that's kind of catching up. When you first said that, I was thinking, okay, wait a minute, it sounded like something was going to be inconsistent, but it actually
Only
sounds
Chicago,
like
though. Keep this in mind.
only Chicago.
Yeah, you get a ticket anywhere other than Chicago, parking ticket, Chapter 7 is not going to help you.
Yeah, you're out of luck
At
there.
all.
Okay. And that's, again, only parking, doesn't apply, obviously, to any moving violations or anything else like that.
Correct. Moving
Okay.
violations are separate. Those are non-dischargeable. They have to be paid.
So in a Chapter 7, is it just one person, or what if you're married, or what if you're living together?
Well, you can file individually, or if you're married, you can file jointly. You have to be married to file jointly. You can't be just two people on the same debt. Those would be bifurcated into two separate cases.
Well, what if now, and of course, there's no need to do that because marriage laws have been changed. So
They have?
They used to have. They have
Completely.
It's completely a civil union. What if you had a civil union? So that was before now that you could certainly marry the same sex either way. But so that would be considered a marriage, right? So you could get rid of.
No, you have to be
Counter.
married. A civil union would
civil
not
union won't
apply.
do
You
that.
have to be
Okay.
officially married under the laws of the state.
Why would if somebody was married? Why would just one person want to do the Chapter 7?
Well, sometimes all the debt's in one party's name, and the
Even
other
though-
spouse has
okay.
no debt. So there might not be a necessity for both to file. But very often, both parties have credit card debt. Both parties might be on some kind of loan, mortgage, car. 95% of the time, it makes sense for both parties to file.
What if again, like you said, it's only in one spouse's name and they file it? Is it going to affect their spouse's credit?
Typically not, unless the parties have joint debt of some sort, because that debt's going to be eliminated too. So if they had a joint credit card,
Well, right, but again, then they would be filing together rather than just a separate one. Okay, so can anybody file a Chapter 7?
any individual can file a Chapter 7. Any corporation can file a Chapter 7.
Is there a monetary limit? If you're taking individual, what if they're making? Is there any limits on what they could be making? So if I was making a couple $100,000 a year, and I just want to get rid of this debt,
You would not be able to file a Chapter 7 if you're making that kind of money. There is a limit. There is a statutory amount based on the IRS guidelines. And then if you're over those guidelines for the family size in your local area, it goes by county,
okay.
then you would be subject to what's called the means test, which is a mathematical formula to determine whether or not you have the ability to repay or whether or not you really need the help and you don't have the ability to pay. And in those cases, you'd be entitled to a Chapter 7.
Okay, so a lot of people think if I'm doing this, and again, typically referred to as a fresh start, if you're doing a Chapter 7 bankruptcy, Dave, sure, I messed up, but I've got this car, and that's the only way I can get to work. I mean, it's a pretty good car, and I need to be able to continue to make some kind of a living. Am I going to lose my car?
Well, it depends. It depends on how much equity is in the car. In the state of Illinois, you're allowed to keep $2,400 worth of value in the car, free and clear, from your creditors or from the trustee.
What if the car is in both mine and my spouse's name?
Well, then that 50% interest of your spouse has to be factored in, so that would be helpful. And remember, there's a $4,000 miscellaneous wild card personal property exemption that could be sprinkled over any kind of personal property. So I mentioned $2,400 in the car.
Mm-hmm.
You also have that $4,000 miscellaneous that you might be able to utilize some of that. So you can basically keep a car if you have $3,000 to $5,000 worth of equity.
But I mean, here's the thing, though, Dave. There's not a whole lot of equity in the car because it's pretty new, and I'm paying on it. So I don't want to lose it.
No.
If I do my bankruptcy, and
You can keep a
they're
car.
going to take the car from me.
No, you can keep a car that you're making payments on with little equity through a bankruptcy. That's called reaffirming a debt. You'll actually sign a special agreement, or a separate agreement, I should say, after the case is filed, that puts you back on the hook for that debt. Because remember, once you file, the debt is technically eliminated if you complete your case and you don't rehook it.
So if I do this reaffirmation that you're talking about, am I out of luck if I change my mind afterwards?
Yeah, that's true. If you sign up for a reaffirmation and the case goes to discharge, and I think another 30 or 60 days passes from when you filed the agreement, you're on the hook. So let's say 6 months down the road, something happens with that car, you can't make the payment, or it breaks down, something like that.
Right.
You're on the hook because you agreed to be back on the hook. You chose to do that.
I've had people who've come into my office and they wanted to keep their car, no problem for the reasons that you said. However, we have to get into a discussion about being upside down on it. So essentially, I owe, let's just pick a number, $25,000 on this car, and it's worth 10.
Okay.
And I always tell people, hey, listen, this is your decision, but you have to understand, 25, 10.
Yeah.
But I'm not going to be able to buy another car, Dave. I'm not going to be able to buy a car. Am I going to be able to buy a car, Dave?
You would be able to. So in that
Right
situation,
after my bankruptcy?
Immediately after the case is filed, there are dealers that will deal with you that specialize in helping people. The interest rate is going to be a little bit higher
Sure.
than if you never filed the bankruptcy. However, you will be able to get into an affordable vehicle. Sometimes they still have warranty left on it. In fact, there's a couple that specialize in helping people with financing after bankruptcy, and they will actually contact those particular people off the filing list, and so they'll be aware of opportunities. But in the situation that you described,
Sure.
let that car go.
Right.
This is your chance in a Chapter 7 to get out of the $25,000 debt on a $10,000 value vehicle and get into something that you're even.
Which is the smart thing to do.
Very smart.
Okay.
You want to rebuild. You don't want to be strapped going forward. You want to be smart.
Okay. So we've talked about the automobile, and then let's talk about the house.
Oh, they have a house too.
I don't. There's a house too, and
Wow.
you know,
I didn't think you could
try-
file bankruptcy if you had a house. That's why.
Well,
I'm kidding. I get
yeah,
calls like that.
You get calls like that all the time. So there is a specific limit in terms of equity.
There's an exemption, just like in the car. We
Sure.
talked about that. There's a $15,000 exemption.
Well, they raised that, didn't they? Not too long ago, didn't they?
Yeah, they doubled it.
Okay.
So
it used to be $7,500
right,
per individual.
right.
And
Now it's 15,000. So a
So if
joint
you're
couple,
married,
30K.
Okay, and so in a situation where only one person is filing, half of that would be attributable to the spouse who's not filing, so I would only have to worry about the half of the amount of equity.
If they're both on the title.
Correct.
There's a little nuance there. That other non-filing spouse has to be on the title for us to factor in their exemption
What if
or
she's
equity.
just on the mortgage?
No exemption.
Okay.
Then we're in trouble.
That she's got to be on the title.
Yeah. Why
So-
would you want to be on the mortgage and not on the title? Explain this to me.
Well, there's a lot of people who apparently, I don't know, they have funny things going. I can't imagine why you'd want to be on the mortgage and not on the title.
You want to be on the hook for a property that you have no ownership
I'd
in?
rather be on the title and not on the mortgage.
Will you sign my car note?
Oh, I'll sign it with my left hand.
Okay.
Yeah, and
Yeah,
I'll,
it just doesn't make sense.
yeah, I'll sign it in the name. I'll use Mark.
Yeah. And be
Yeah.
careful who you co-sign for,
Yeah.
too. I've helped a lot of people that got into trouble, not because they didn't pay, but
Correct.
because the
Well-
person they had faith in to make the payments did not.
Explain how that works.
Well, if you co-sign a debt, you are joint and severally liable.
So that means if you bankrupt the debt that I co-signed for you, they're coming after me.
That's right. You might be filing bankruptcy, too, depending on what the
Wow.
deficiency on that car is.
But my nephew,
Or mortgage or
my
a
nephew
credit
asked
card.
me if I could really. So,
Your
so I guess
nephew.
right,
There's the problem
there's
right
the
there.
Go. So
Yeah.
it could be family or friends, and so I guess the smart thing is, hey, just don't co-sign.
Could be a boyfriend or girlfriend, typically.
Oh yeah, that's probably even the worst of the deal.
Yeah.
To
And they're both on the apartment lease, and guess
Right.
what? They're both not staying in that apartment for the whole term.
So they're coming
That's another
after one or
issue,
the
yeah.
other. Sure.
Yeah.
Okay.
Life lessons, man, they're hard.
Life lesson. So we have a little more time. Let's talk about the process. Okay. So before we do the process, because Chapter 7 and Chapter 13.
Well, you get due process.
Right. Well, due process. That's very important. The process between both of them are similar. So before we talk
Right.
about the process, let's talk a little bit about, I guess, then the Chapter 13, because you said earlier that if I
Yeah.
made too much money, there's a mean test. If I am not able to pass that, then I might have to end up paying some of it back or all of it. So what is
13 is a very complicated case from the attorney standpoint, from the financial aspect of it, but from the consumer portion, it's relatively simple if you think of it like this.
Sure.
You're taking someone's income, you're subtracting their monthly expenses, not including the debt, but just normal expenses, food, clothing, shelter. Whatever that difference is, whatever is available per month,
right?
is known as the disposable income.
What if there's nothing left after the disposable income?
Then they're not in a Chapter 13.
They can't do a 13.
You have to have the ability
So-
to repay in a 13.
Well, let me ask you
something.
this. We go out to dinner a whole lot, so, usually we spend like, 12, $1,500 a month on food. So
Yeah, that's a problem.
why is it a problem?
Well-
you got to eat.
We have to adhere to the IRS standards for what you can spend per month for food, clothing, shelter. And if you exceed those amounts, you're basically favoring yourself and your lifestyle over what the IRS says is the norm to the detriment of your creditors.
Are
So
there
you're
any
going to have to
exceptions?
stop that.
What happens if I'm a rather large person?
Well, you still can't spend $1,500 a month on food, I'm sorry.
Well, I understand. Or what if I have, like 12 kids?
Well, yeah, the more children you have, the more people in the household, the more the allowance goes up. Special needs children's
Okay.
would be an item where you can spend more. Special diet, medical issues, but absent one of those circumstances.
Medication?
Yeah, yeah.
Okay.
It might have to be documented. The trustee is going to look into
Okay.
whether or not that's a legitimate expense. Tithing, charity.
Tithing, I was just going to ask you about that. Yeah, so we,
Yeah.
we tithe 10%. So what, and we always do. It's not like, okay, right when I filed this, I all of a sudden started,
Well, I think you can do that
tithing.
too. There is no requirement that you had to be tithing for a certain number of months beforehand. Someone could argue bad faith, but who can question when
I
you
can
found
argue
God?
I just got religion, right? Yeah, I just
Right.
found God. So, okay, so, all right, so you could do that too. All right, so then what happens then? So you talked about this disposable income.
Yes.
So in a Chapter 13, basically what am I doing? Who am I paying?
You're paying a Chapter 13 trustee who is an individual who, much like a dealer in poker, is going to deal out a little bit per month to all of your creditors. Okay? That's basically how it works. And it runs for 3 to 5 years. And
That's
at the
a
end of
long
it, you're done.
So, so basically, what I'm understanding, or maybe we hadn't said this, that in a Chapter 13, you have to pay your secured creditors 100% of what you owe within that 3 to 5 years, and your non-secure,
A percentage.
as little as 10%, all
Yeah.
the way on up to.
And actually, if you have a car that's more than 2.5 years old that's financed, you don't pay that in full either. You pay kind of the market value of the car at 6% interest. So there is a little bit of a break there on an older vehicle.
Sure.
But the amount you pay per month and the amount you wind up paying overall is based on your income, your expenses, your assets, and your liabilities. So it's
But-
a complete mathematical formula that's software dependent.
But after that time, the 3 to 5 years, all that's paid off.
You're done
Now, what if
in a
I
typical
have
case.
What if I have student loans? I mean, I'm pretty sure I'm not going to be able to pay the hundreds of thousands of dollars in student loans off in that period of
Well-
time. That's going to throw me over the top. Is that going to make me not eligible for being able to do a Chapter
No,
13?
there's different ways to treat student loans. You can pay them a percentage through the Chapter 13, let's say a 10% repayment plan,
Okay.
knowing that at the end of your Chapter 13,
I'm still going to have to pay in the whole dealio.
you're going to owe the other 90% plus interest.
Oh, plus interest. Okay.
Plus interest. That interest keeps accruing on a student loan. So and you could also treat the student loan outside of the Chapter 13 completely and pay it separately. If you have some kind of forbearance agreement or
Or will
a
they
lower
let me
monthly
pay
payment.
if I'm making payments? Will they let me pay independently of the Chapter 13?
Yes.
The trustee
They will, in certain
That's the only
cases.
exception, though, is student loans, nothing else.
Certain things you can do. We're getting pretty creative with the plans, but for the most part, you want to have all your creditors being paid through the Chapter 13 for the protection of the client.
Okay. And so we're looking at that. So what happens in terms of a house? So let's say, all right, so I have to only pay if I'm behind on the mortgage. I have to pay whatever I'm behind on, but at the same time, I have to maintain what the current payments are.
That's correct.
Okay. So what about if I have equity on that as well that exceeds the value of my home?
Well, you keep the equity in your property when you're doing a Chapter 13 because
Right.
you're repaying.
But what I mean is, what if the value of the home is exceeded? So it's basically it's not worth what I owe.
Oh, you owe more than what the property is
That's
worth.
correct, right.
Okay, well, if you have one mortgage
Right.
and you're upside down, you have to continue to pay that mortgage if you want to keep the property.
If I don't want to keep it, I have an option to treat it as a non-secured debt.
You could surrender it.
Okay.
Yes, you could. Most people don't want to do that, though.
All right. What if I want to keep it and that's fine, but what if it's the thing that's really killing me here is the equity line that I have on
Oh, the second mortgage.
the second mortgage.
Okay.
Yeah.
If the property is underwater to the point where it's less valuable than the first mortgage.
Right.
So the second mortgage is completely underwater, unsecured. There's a way to strip that lien and basically pay it back at a percentage. but we're not seeing as many of those anymore because the market has turned. We're off the bottom. We're way off the bottom now.
Okay, so that's different.
Yeah.
So let's talk, because I also want to talk about our interplay again. We talked about bankruptcy and
Let's do it.
and divorce, but before we do that, in terms of the process for the bankruptcy, either one. So either one requires a debt management course that you have to take ahead of time before you file it.
Yeah, credit counseling
Credit
course. It's
counseling.
90 minutes on the phone.
And
Not
then
a big deal.
One that you have to take afterwards before you get your discharge.
2-hour financial management class.
Okay. And
No big deal,
because
yeah.
I have those, it's going to make me being able to to avoid this pitfall again.
Yeah.
So that being said, am I going to have to go to court? Am I going to have to talk to anybody or testify or do
Yeah.
anything?
You're going to have to go to one meeting of creditors where you
Okay.
meet the trustee.
Okay, so it's a meeting of creditors for Chapter 7. What is it for Chapter 13?
Same thing.
Same thing. And okay, so what are they going to ask me?
Well, they're going to ask you a series of yes/no questions. They're going to go through some of your assets,
Sure.
your liabilities, where are you working, what property do you have, did you sign the documents, did you list all your assets and liabilities, can you sue anybody for any reason, personal injury, workers'
Which would all be in your
compensation?
petition in any event?
Yeah, they're basically verifying the information
All right.
that you gave to your attorney, that your attorney prepared, and then filed with the court.
What about the Chapter 13? So it's the same thing, meeting of creditors, but the trustee is really looking at to make sure, hey, that the plan is okay. Can I ask the same questions? I've heard trustees ask before, if, for example, if you're making a voluntary contribution to your retirement, I've seen them stop that. So for the time of the plan, however it is, 3 years or 5 years, you have to stop that contribution because it's not mandatory.
Yeah, it's going to depend
To
on
be
the
able to
case,
fund
but-
the plan a little bit more.
Yeah, it also matters too if you're repaying 100% or 10%.
Right. So if you're repaying 100%, it really doesn't matter so much.
Right, the trustee is a lot more
Right.
lenient
Yeah.
in terms of budgetary items. Your food budget would probably be allowed if it was 100%
Because you're
repayment plan.
repaying it anyway. Okay. So now that we've talked about that, and I think our audience maybe has a flavor for kind of the bankruptcy aspect. Now, in a divorce, again, so basically there's a bankruptcy estate, and that's true whether or not it's individual or whether or not it's a husband and a wife. So typically when somebody gets a divorce, all right, so it could go either way. I've seen them either way. Where, all right, now, hey, there's a lot of debt here, and we filed our divorce. There's a lot of things to do with your divorce. You file your petition. You exchange financial affidavits and disclosure, and people do discovery because basically it's about just dividing up the pie to find out, and we hit on that earlier, on what's equitable. Okay, how much do you have? What do you make? What's your expectation of future employment to be able to take care of these things? Is there going to be maintenance? Is there going to be child support? All these other things. So now, if we have a debt and the parties are not in par in terms of, hey, listen, because it would be easier before they started that process to do the Chapter 7 if they could to get that taken care of. But not so much if it's Chapter 13 if that's going to go on for another 3 or 5 years because I can't even stand another 5 minutes with you, okay?
Right.
All right. So we're looking at this. So now you have one party who, during our divorce here, we've already filed it, files a Chapter 7.
Mhm.
So now, when you file that, you mentioned there's an automatic stay.
Right.
And so what we do is we bring it to the judge's attention because generally it stays, because again, the divorce proceeding is dividing up it's a marital estate. And now one person is filed, and now that's the bankruptcy estate. And so now the bankruptcy court, federal, has jurisdiction over those monies and those debts and those assets.
Right. It typically takes about 110 days from start to finish in a Chapter 7. So if the litigants in the divorce are willing to wait out that time period, they won't need to do anything further in the bankruptcy court to be able to proceed
Right.
with their divorce. They just have to wait.
They have to wait. So in other instances, what we've done is because the bankruptcy or the divorce court will wait. They won't touch it. They'll just put it on bankruptcy status and come back after that time. But sometimes what's happened is we'll have the bankruptcy lawyer request that they go in and file a motion to stop the stay as it relates to the divorce.
Right.
And so once that's granted, we're free to proceed.
Right. And there are some things that are not state at all, like child support, maintenance, I believe you can pursue that.
Right, maintenance.
You just can't really divide the property up and get a judgment that's dividing property while the bankruptcy is pending without court approval.
Right, with in terms of the selling of the house,
Yeah.
or if the house is going to be with somebody else. But if the stay is gone, the stay is gone, but the bankruptcy court still has that jurisdiction.
Right.
All right. So, so this is important for people to know as well. So let's say, all right, even if you did it before, so you went out there and you got your bankruptcy, so now all of your debts are wiped out, even though there were some of them that were joint. Guess what? Guess what the divorce judge can do, Dave? Hey,
That judge can
ooh,
order
you know
you
what?
to pay debt that you discharged.
Your debt right here, Dave, is discharged, okay, in the bankruptcy court. But guess what? Because this is a court of equity, so I'm going, even though that's that portion of the debt for the joint portion, and now your situation's looking brighter because you don't owe that money. So guess what we're going to do, Dave? We're going to shoulder not only you with the joint debt, but with some of his or her personal debt.
Right.
Because now that's freed up.
Well, that's why it makes sense to file together if you have a lot of marital debt.
Right.
Or at least wait till after the divorce to see how the debt's going to be apportioned, because it just doesn't make sense to file early and then
Right.
have a divorce judge reissue it.
Right, and I think it's important then to keep your lawyer involved, both of them. Okay, so if you're going to do that, if you're working with a divorce lawyer, hey, and you want to have that discussion about, hey, I'm thinking about doing a divorce, and then you want to have that discussion about, okay, well, maybe both of you can do it if you can, and try to make that happen.
Right.
But don't just go out there and do it. What do you think about people filing their own bankruptcies, Dave?
I don't recommend it. There's just too many holes that people can fall into and trip over. There's too many deadlines. There's too many proper
Technicalities,
things. Yeah,
yep.
It's not something you want to do yourself. Right. Even though they revised the forms a few years ago to try and encourage more people to
Right.
do it themselves, they've actually made it more difficult by doing that. The forms were easier before. They're really difficult now. I don't recommend it. It's something that hopefully you'll only have to do once. Most attorneys will put you on a payment plan. You're not having to
For the bankruptcy.
fork
right,
over
yeah,
a bunch of money all at once. In fact, many will file with just the filing fee down and the payment plan on the attorney's fees. So I don't recommend
Well,
people
that
do it
doesn't get
themselves.
discharged?
No, it doesn't, as long as there's a separate agreement entered into called a post-petition retainer agreement, which basically bifurcates what's happening before the case is filed and what's happening after, and that's what we use.
Okay, well, that's very handy there, too. And on the same note, in terms of doing a divorce, there's a lot of state forms, a lot of folks out there that will prepare forms for you. That may or may not be good. If it's a lawyer who's going to prepare forms for you on your unique situation, okay, that might not be so bad. But you want to stay away from people, who really aren't lawyers,
Yeah.
okay? Or even though the state forms, they have the forms that you can just check off. If you don't have anything, and there's no assets whatsoever, you might be able to do that.
Yeah.
But really, realistically, if it's going to come back, and I've seen it, it's going to come back to bite you, and it's not going to be a very good bite, okay?
Right. I've seen many people ambitiously try and do it on their own, only to realize that the case got dismissed or they didn't complete it. Now the creditors are coming back after them, and they want help. And
Right.
usually it involves refiling a case.
So you're having to redo that thing, so might as well just do it right the first time and get it done.
Right.
Yeah, yeah.
Yeah, there's a lot to it.
If
So
there's
make
back
sure
to it,
if
right.
you have a situation where you're struggling financially, don't try and go it alone. Good to see you, Jesse.
You as well, Dave.
Thanks for your good information as always.
Dave.
We'll see you next time on Legal Action. Take care.